Number 61, matter of Honorable Richard H. Miller. Counselors, did you want to stay or did you?
I think
You gonna leave? Okay. All right. So if you'll just give us a minute on number 61.
May it please the Court, may I reserve 2 minutes for
2 minutes? Yes, you may.
Thank you. The Commission and its counsel are asking this Court to ignore, alter, and reject significant credibility findings made by a referee after a 6-day hearing, made by a preponderance of the evidence.
Are we bound by the referee's findings, and is the Commission bound by the referee's findings?
You are not, you have exclusive fact-finding power. There's no question about that.
One of those rare instances, right?
That and death penalty cases, which tells you how important judicial matters are when it comes to finding facts. But if you look at the history of this Court's decisions, such as in Barronhouse, the tremendous deference that is given to referees who have the ability to make determinations of motive and intent based on observations that what this Court calls a lifeless record would not do. And that's why the language of the referee is so powerful when he talks about rehearsed and coordinated testimony of deceitful and lying individuals that, quote, defy reason. And the one word that I would take from the referee is this: troubling. Because that's what Justice Miller of the Appellate Division, who sits on the Commission, said at argument. He says it in his dissent. This is troubling when you look at the unfounded allegations and the pall that it casts over.
Well, since you bring that up, don't you think it's rather unusual that character witnesses as to the Commission's witnesses were essentially allowed to be called? I mean, you know, if we start looking at that, and if that were to happen in most trials, that would be most unusual. You're just going to end up in this collateral mini trials about the credibility of the witnesses with all sorts of witnesses called. I found that quite astounding myself, that the referee allowed that.
It was very important, not just for the Commission witnesses, but for Judge Miller. The character testimony addressed several factors. One was truthfulness. Individuals were testifying. Judge Miller...
Well, what's the authority to allow that kind of evidence even?
The general authority for character testimony in proceedings in this state.
But the character witnesses that we typically allow and reputation witnesses that we typically allow aren't usually allowed for fact witnesses as to what happened, whether it's in a criminal trial or a civil trial or I mean, it just, that would spin out of control.
No, in criminal trials, like in Paveo, this Court said that the history and reputation of an accuser, for example, that reputation for truthfulness is extreme.
You know, this almost, to me, you're almost, that's saying is, you know, we can't allow things like the rape shield law. It's not really a point that I think is necessary to the decision here. And I would ask you to perhaps move on to what is an appropriate sanction here and why.
One thing that the witnesses in the record established, when I say witness, the character was not just truthfulness, but also, here's a judge from 1994, about 23 years when the hearing was held. In the past 26 years, what is his record of making comments like this? Is there any history of this? Or are these isolated and aberrational comments?
Okay, but there were things other than I assume you're referring to the sexual comments, but if that was all that was on this record, we might have a different question before us. But as I see the question before us is whether even just limiting it to the facts as found by the referee, many of which the judge conceded had occurred, and if we look at them in the aggregate, does that warrant the remedy of removal?
It does not, because there are two that the referee found with respect to one clerk, and another time that he told the clerk to hurry up. That's what the referee found. He specifically did not find what's in the determination. There are many conclusions there that are not the referee's
But
finding.
is there not support in the record for the commission's conclusions in those regards?
I respectfully submit that's why the referee is so important. When he heard
But the referee, I think we can all agree that the referee is important. I mean, there's a reason why the referee takes the testimony in the first place. There's no question about that. But you seem to be suggesting that neither the commission nor any court can vary at all from what the referee decides.
I am not suggesting that. I am suggesting not only that deference is ordinarily due, particularly on credibility, but when you look at the record, why all of a sudden in 2017, in a 3-month period, does this behavior and conduct occur? Not once does the commission bring proof in or question any of the character witnesses about some incident that happened since 1994 while this man has been a judge at the local court level.
But again, Counselor, we're not looking at this in isolation. We're looking at this in the context of a former censure. We're looking at it in the context of some serious financial irregularities, and we're looking at this in the context of the use of court staff to do extrajudicial business.
Okay.
To me, it's that combination that we have to be looking at. Sure, if you take each and every individual allegation separately, would any one of them warrant removal? I don't know, but that's not what we're looking at.
And there's a lot to unpack in your question, Judge Stein, but let me address the financials, because the other major flaw and damning thing that the commission does to this innocent person when it comes to the financials is he goes to his accountant after April 15 to identify a problem. There's not one case in the history of this state at the commission level or the Court of Appeals level where a judge is sanctioned when he comes forward voluntarily to make those corrections. And this isn't just his testimony. It was supported by an accountant, and you don't read a word about that in the determination. The referee said this is very important when you look at sanction, which is your question, Judge, is the timing and how he behaved. This is long before there's any type of inquiry, and it's also after they take his papers. They take his papers and then expect him to be able to do this promptly. It's amazing he got his papers and returns in by August 2. This is unrebutted by the accountant, and I think that's extremely important when you look at the history of financial disclosures. There's cases like Russell, 13 times they sent a notice. This judge never got one notice, but he was taking action on his own. And I think that's one of the most, to me, concerning things about how the commission wrote that decision, is not recognizing a key fact that is not only found by the referee, but supported by the accountant's testimony.
Okay, thank you. You have your remaining time in rebuttal. Counselor?
Thank you, Your Honor. May it please the Court. The petitioner here committed various repeated acts of serious misconduct, some of which involved sexual innuendo, there were financial improprieties, and there was an issue of dishonesty in terms of the letter that his court secretary wrote in the name of someone else, which the petitioner knew and had her do. Putting all of these facts together with the fact that he has been previously censured, and which the commission found he did not accept responsibility even to the end of the proceeding when he was appearing in person before the full commission. He had different explanations and different answers on various occasions that he was put to the test. He made several unwelcome sexually charged comments to one subordinate, Ms. Singer. He unreasonably screamed at and demeaned another, and then he retaliated against her when she complained about him, and he put the onus of stopping his misbehavior on them. He said All they had to do was tell me they were offended, and I would have stopped, which is really putting the cart before the horse. In this day and age, a judge should not be told not to engage in this kind of behavior. And in fact, in matter of Collazo, this court said specifically that a ribald remark or an indelicate suggestion to a judge's subordinate, even if meant in jest, is demeaning, inappropriate, and deserving of some sanction. Collazo was removed because there was aggravation and there was additional misconduct. Here, there is aggravation. He's not owning up to his responsibility. He's denying some of the statements that were made. And there is plenty of other additional misconduct. With regard to the...
Do you agree that deference is owed to the referee's findings?
Deference is owed to the referee's credibility findings. We vigorously contested those before the referee. He found two witnesses primarily not credible because he found that because they were suing the court system, they had a particular motive to exaggerate. In our presentation to the commission, commission counsel did not rely on facts pertaining to those two witnesses. Even though we disagreed with the referee's findings, we based our argument that the record before you and the determination before you should be sustained and removal should be the appropriate result.
Well,
because
and
all
even
of that
the
was
dissent
supported
here-
by extrinsic evidence.
I'm sorry. Even the dissent here is not disputing the existence of misconduct. So
That's
what
correct.
we really hear about is sanction.
Yes, the dissent even
And,
begins by adopting the facts.
To the extent that it's aggravated by what I actually find very serious, these financial reporting violations and or tax, the appellate division is constantly disciplining lawyers for misleading tax returns or failure to file tax returns and so on and so forth.
As this court has.
And my question is, what is your view of your adversary's argument about the timing versus what was actually found about the timing?
If we were looking at any single omission, one might be able to credibly make the argument that there was inadvertence here. Even if that's the case, in Alessandro, you found that even the inadvertent failure to report accurately on your financial disclosure forms is serious misconduct that deserves public discipline. Here, we have a collection in a relatively limited period of time, which suggests that he was knowingly omitting. For example, he had notice in April of 2016 that he had to report extrajudicial income to the clerk of his court. He didn't do it until 2019, after the investigation was over and while the commission hearing against him was taking place. In July of 2017, he knew that the commission had his financial and tax records and that he was being investigated, not only by us, but by the Inspector General of the court system. He amended his tax returns in 2017, but it wasn't until November of 2017 that he admitted that he amended one of his financial disclosure forms, which still is inaccurate, by the way, 12 days before his scheduled testimony before the commission. One, maybe two, maybe even three could be explained as an inadvertence or a coincidence, but put them all together with the failure to report $67,000 worth of extrajudicial income from this law practice and from rental properties on 2 tax returns, on 2 financial disclosure statements, and failing altogether to report 3 years to the clerk, it's hard to come to any other conclusion that there was a willful omission. But you don't even need to find that it was willful. Would you respond
to the argument that the transgressions here were unrelated to the 2002 censure?
Well, it shouldn't matter, Your Honor, because as you said, in Doyle and in O'Connor, a prior censure is serious misconduct, even if it is unrelated. But there is one thread which links them to this. The 2002 misconduct involved an intermingling of the respondent's legal obligations, because he was a part-time judge practicing law, and his judicial responsibilities. Here, the failure to disclose on public documents led to a situation which this court has previously criticized or noted as significant, which is to say that a lawyer or a litigant trying to determine if the judge has a disqualifying interest and should be the subject of a recusal motion is denied the information they need because the finances are not properly reported, which means that his extrajudicial income, including from the practice of law, is not there for litigants and attorneys to see and determine this might be a conflict that I want to make the subject of a recusal motion. They're denied that opportunity. And if you look at his explanations for them, they are the basis of what the commission found as baseless, nonsensical. They just didn't make sense. He didn't report extrajudicial income from his law practice in 2015 because he thought he cashed the checks in 2016. But then he didn't report them in 2016 either. Rental income that was not reported on his federal and state tax returns, but as to which he claimed deductions, clearly suggests that he had in mind these rental properties when he was filing his taxes and doing his responsibility as a citizen, and yet he failed to disclose to the federal government and the state tax authorities that this money was out there. And when he did finally amend, it increased his tax liability. At the same time that he's not reporting it on his financial disclosure statements, and at the same time that he's not filing any claims or notices of extrajudicial compensation at all to the clerk of his court, despite ample notice to do so. Added to his use of the secretary to type a letter, which admittedly, in and of itself, would likely not bring us here, except for the dishonesty in having her sign someone else's name, the name of a secretary at the law firm where he used to work. He engaged in an act of dishonesty that is inimical to the role of a judge. And his participation in this wasn't hands-off. He had gone to the law firm at which theoretically, or so he says, he had no more business, collected the mail, brought it back to the courthouse, opened a letter that was not addressed to him, but was addressed to a lawyer at that firm, found the checks that were unsigned, had his secretary write a letter. Admittedly, he was entitled to the money that was reflected in those checks which were not signed.
And hopefully, if he got them, he would report them on the appropriate taxes and financial disclosure
Well, he
forms.
should, but he didn't. And in any event, he should not have had his secretary sign someone else's name to it. It's a deception that no judge should participate in. And then, by the way, he walked the letter back to the law firm so that it could be mailed from there to the individual who was going to provide essentially money in his pocket. Even though he was entitled to that money, he was not entitled to have his court secretary lie about who she was on a document that she prepared and that he had delivered. When all of this is considered in totality, there is no alternative, as the commission found, and as I pray that this court will find, that removal is the appropriate result.
Thank you, Tom.
Thank you very much.
I want to go back again to the timing on the financial matters. Judge Miller did what every citizen in the United States should do. Check with your accountant. Should I file a return now and amend it, or should I wait? He followed the
Do you
advice
think
of
every citizen takes deductions without reporting the income that they're taking the deductions for?
He knew that he had a problem in April 2017 concerning not only the income from the practice, but also his properties. This was part of the carelessness that the accountant described and how Judge Miller produced his returns. It was her opinion to go forward even though he didn't have all the information. There's nothing illegal or wrong about doing that and doing the best you can at that time with the advice of an accountant. This is not a man who operated on his own and held back. I'm not going to do anything about this until someone brings to my attention or catches me. And this is what's so fundamental, because that's omitted from the argument, not only today, but in the determination, that it was unrebutted, that he made that effort and followed the advice. He listed all these properties on the original financial disclosure forms. Yes, he knows he has properties, he knows he has expenses, and to call it $67,000 is totally misleading. There was $27,000 that resulted in income that had to be taxed, and he paid taxes for 1 year on that. The other should be identified on the return, but there was never any income paid, or there was no net income from that. We talked about what the instructions indicate for that. So I think, as I said, we still didn't hear one case where a judge has been sanctioned at any level for voluntarily trying to correct his returns, and doing so, that just hasn't happened before. And he never even had a warning on that. And I go back to the aberrational nature. Even 2002 is not connected. It is attenuated from the conduct in this case. It took place around 2000, 1998, 2000, and you have to look at an entire career. We're dealing with 26 years, and I think that's where the testimony of witnesses who saw him all around, that could have cross-examined them about some other incident, it just seems so unusual that all of a sudden in this 3-month period that these acts took place. And I point out that one of the acts, which the Commission claims happened, could not have happened on that June 5th day, when the witness who claims it happened wasn't even working that day.
Thank you, counsel.
Thank you.